Hello everyone, my name is Sabik and you are watching YouTube channel of Legal Eagle. In the last class, we discussed about Article 13 in Part 3 of the Indian Constitution and we got to know about what are laws and what are laws inconsistent with Part 3 of the Indian Constitution and whether they are void or void ab initio. Now proceeding towards the next article, which is Article 14, which talks about equality before law. Now, what does Article 14 state? Article 14 states that states shall not deny to any person equality before law and equal protection of laws within the territory of India. Now, this is a simple article with only two lines and some important keywords like equality before law, equal protection of law within the territory of India, and also it states that states shall not deny equality before law to any person. Yes, the word used is person, not citizen. So, what we can understand from this is that Article 14 extends to even citizens and non-citizens. There are some articles which you should always remember that only apply to citizens. It is very important to remember these. Just remember 15, the next article 16, then proceed to 19, add 10, which is 29, and next article, Article 30. These articles apply only to citizens. 15, 16, 19, 29, 30 15, 16, 19, 29, 30 only apply to citizens. Rest, all other articles which are given under Part 3 is applied to both citizen and non-citizen. In simple words, Article 14 states that state shall not deny to any person equality before law and equal protection of laws. Now, some keywords to keep in mind are state, as we know under Article 12. It is now very clear to you that what is state and why it is important to claim fundamental rights against state. What's the duty of the state to protect your fundamental right? Another word is shall. It's a mandatory. Shall is used when the thing is mandatory, when it is confirmed. So it is the duty of the state. What? Duty to not deny to any person. As I mentioned, to any person means both citizens and non-citizens. What does the state shall not deny? Equality before law, which means that each and every individual, whether he is rich, poor, male, female, child, adult, president, prime minister, governor, any IPS, IAS officer, or any person who is currently in the territory of India, whether he is a citizen or non-citizen, they should all be guaranteed equality before law. If they have contravened any law, then each and every individual should be treated equally, and law should see them with only one vision and should not discriminate between them. And it also says that states shall not deny equal protection of laws. Then equal protection of laws means that if two persons are equal, then the laws applying on that two individuals should be equal. But if two individuals are unequal, then the laws applying should also be unequal. They should not be treated at par when two people are unequal. Equality before law, it means that every individual, these two individuals, they are equal in the eye of law. Whether he is rich, this is poor, this is child, this is adult, this is male, this is female, this person belongs to a particular state and this person belongs to a particular other state. But in the eyes of law, these two are equal and they are not above the law. The law is above them. And in the eyes of law, they will be treated equally. The same law will apply to each of them. Equality before law is a part of rule of law. Rule of law is a concept promulgated by Sir Edward Dicey, which means that there should be a rule of law and not rule of people, so that the law can treat each and every individual equally and the law applicable to both individuals should be same. In Article 14, there are two concepts of equality. First, there is a negative concept and another one is the positive concept. As we talked earlier, equality before law is a negative concept. Equality before law is a negative concept under Article 14, which tells that all individuals are treated equally and they are below the law, and both individuals should be treated by law equally. So this is a negative concept. The other concept, which is known as positive concept, this is concept 1 and article positive concept. This is taken from the 14th Amendment of American Constitution. The positive concept, as I told you earlier, the positive concept of Article 14 is equal protection of laws, which means that if these two individuals are unequal, that means if this is child and this is adult, then we cannot apply the same law to both of them. Like if this is a child and, for example, if this person is a child and this person is adult, a child has committed a crime under IPC and an adult has committed a crime under IPC, then the same IPC cannot be applied to these two individuals because this person is child and he is unequal to an adult. This person will be governed by Juvenile Justice Act and this person will be governed by IPC. In the same way, there can be many situations in which two persons, not only in criminal sense, but there are many times unequal laws are applied to unequal persons. Like if a person belongs to a marginalized community, okay, this person has been historically subjugated by the society. That means they belong to the OBC or the SC or the ST, and this person is a upper caste individual, okay, who belongs to general category. So there is a provision that equal protection of law applies to these two people. These will be governed by different law and these will be governed by different law on the basis of just, fair and reasonable laws. So that the law is not arbitrary and it should be reasonable. Ideally, the laws applicable to both of them are same. But if there is a reasonable classification, intelligible differentia, then different laws can be applicable on these two individuals based on the standing of these individuals in the society. Justice Bhagwati J has said that equal should be treated equally and unequal should be treated equally. So if you understand the concept that these two individuals, like in case of child and adult, in case of OBC and general category people, different law applies to these people and they get reservation, they do not get reservation. These are governed by the juvenile justice and these are governed, adult this person is governed by the Indian Penal Code. In the case of E.P. Royappa versus State of Tamil Nadu, it was held that equality is a dynamic concept and equality is antithesis to arbitrariness. It is a new concept of equality which was laid down in E.P. Royappa versus State of Tamil Nadu. Under Article 14, as we understood that there may be cases in equal protection of laws where different law apply to different people. Unlike people can be treated unequally and like people treated can be unequally, which is the positive concept of equality. But there cannot be class legislation. The government cannot form a class and say that this law particularly applies to this class. But there can be reasonable classification and intelligible differentia. What is reasonable classification and intelligible differentia? It means that the classification which is made by the government or the parliament should be reasonable. It should promote some social cause. It should promote some justice. It should promote the rule of law. And also there should be intelligible differentia. That means some mind has been applied by the parliament. Some intelligence had been applied by the parliament and to differentiate between two classes of people. It is for the judiciary to check whether a law which is passed by the parliament or with the discrimination which is made by the parliament as a reasonable classification, or is there an intelligible differentia to apply different law to different people or different part of the state. If judiciary finds out that there is no reasonable classification and no intelligible differentia, the judiciary may struck down that law as arbitrary. The court has to make sure that if the law is made and there is a reasonable classification and intelligible differentia and there is a discrimination between two classes of people, then that law, that discrimination should be just, fair and reasonable. Another landmark case, Menaka Gandhi versus Union of India. In that case, a particular section of the Passport Act was held to be violative of Article 14 and Article 21, and also it hindered. Actually, the Passport Authority of India seized the passport of Ms. Menaka Gandhi due to some reason, which was not told why her passport was impounded, and Menaka Gandhi approached the Supreme Court and said that her right to visit abroad or be in any part of the country or world has been infringed. Right to movement has been restricted. The right to movement has been restricted, as Article 19 gives you right to movement throughout the India and throughout the world. So it was held that the law made by the Parliament for the Passport Authority, Section 10(3)(c), Section 10(3)(c) of the Passport Act was held to be violative of Article 14 and Article 19. Why Article 14? Because it was held to be arbitrary. There was no intelligible differentia. Okay, and the law was not just, fair and reasonable. It was Section 10(3)(c) of the Passport Act was violative of Article 14, as it was held to be arbitrary, as it was not having intelligible differentia. It was not just, fair and reasonable. And why it was against Article 19? Because it took away Menaka Gandhi's right to move abroad or settle in any part of the country or the world. And also it was held to be against infringing also upon Article 21, that is right to life and personal liberty. Her personal liberty was constricted because her passport was impounded under Section 10(3)(c) without giving any notice why her passport has been impounded. Now we all know that the fundamental rights are not absolute. It can be taken away due to certain restrictions. There are certain restrictions on fundamental rights. Those restrictions should be by the procedure of law. Procedure should be just, fair and reasonable, and there is a procedure prescribed by law. If a law has been passed and the court thinks that it is a reasonable thing to do, or it is reasonable to curb some fundamental right on some grounds like public order, health, morality, friendly relation with another nations, defamation, incitement to an offense, these kinds of restrictions can be imposed if the exercise of fundamental right is causing these kinds of problems. State of West Bengal versus Anwar Ali Sarkar. In this case, it was held that the classification made by the Parliament or the law-making authority for the offences under IPC to be tried by a separate court or a separate procedure was arbitrary, and no intelligible differentia was applied in putting different section of IPC in one act. The second case we read is Menaka Gandhi versus Union of India. In this case, the Menaka Gandhi's passport was impounded under Section 10(3)(c) of Passport Act, and Menaka Gandhi approached the court stating that this section is violative of Article 14, as it is arbitrary. And we all know that the court has held in various cases that a law should not be arbitrary, should not be unreasonable. If there is a classification made, that should have a reasonable classification and intelligible differentia. Also, it infringed her right under Article 19 to move freely in any part of the India and the country and the world. So also this, and also her right under Article 21 was also infringed, as it relates to life and liberty. Article 21 relates to life and liberty. Her life and liberty was restricted by impounding her passport. So we find a golden triangle of 14, 19 and 21. This is known as golden triangle. If we need to check whether a law is reasonable or there is intelligible differentia to make that law, we test with this triple test. If it's not violating Article 14, if it's not Article 19, if it's not violating Article 21, then we can say that the law is just, fair and reasonable. The only way the fundamental rights can be infringed through procedure established by law. That means if a parliament makes a law and gives a reasonable reason to curb some fundamental right, then that law can take away or abridge your fundamental right to some extent. The other case is Air India versus Nargesh Mirza. In this case, Air India made a circular or put out a circular which stated that if a cabin crew is pregnant, then she will have to resign from the job or she will be terminated from her job. Now, this rule which made it that pregnant woman, if she is pregnant during the course of employment, then her job can be terminated. This was found to be violative of Article 14 and it made discrimination between men and women on unreasonable ground. Why is it unreasonable ground? Because it is clearly known that if a female, she is working and she throughout the job she gets married, she will definitely have a child. Nah? How can you terminate someone from service for following the natural process of life? Like being married and getting pregnant is a natural process of life. But on the basis of that, there is a discrimination made between male and female because male is not going to get pregnant. So this was held to be violative of Article 14. Another landmark case is Mithu versus State of Punjab. In this case, it was a law was made by the Parliament that if a prisoner is undergoing a life imprisonment and then he commits a murder, then he will definitely be sentenced to death. But we all know that in all cases of murder, death sentence is not an option. But this law made that if a prisoner who is undergoing a life imprisonment, if he commits a murder, then definitely death sentence will be provided under section 303 of IPC. The court found that this law is violative of Article 14. Why? Because it differentiate between a normal person who commits a murder and a person undergoing a life imprisonment and then commits a murder. So this was held to be violative and section 303 of IPC was struck down as unconstitutional. Another case, National Legal Services Authority versus Union of India, it was held that the word person used in Article 14 does not only mean male and female, it includes transgenders and other queer genders. It is inclusive of all the genders which we know of. Another very important case which came up is Navtej Singh Johar versus Union of India. The question in this case was section 377 of IPC, which criminalizes homosexual acts between two individuals of same gender. Now, the court held that this is violative of Article 14 it makes discrimination on the basis of gender, and it was also held to be violative of Article 21, which relates to life and personal liberty. Now, this section 377 has been partly recognized as unconstitutional as it decriminalizes homosexual act between two individuals if done in private space. Indian Young Lawyers Association versus State of Kerala, famously known as Sabrimala case. In this case, we all know there is a Sabrimala temple in which the women who are in their menstruating period, like from if we say 15 to 50, the menstruating period of the women, those women were not allowed to enter Sabrimala temple. This came up for consideration in the court and it was held to be violative of Article 14, Article 15. Now, all age group of women are allowed to enter Sabrimala case and no discrimination is made on the basis of gender. This was all about Article 14, though it was a small article which stated that state should not deny to any person equality before law and equal protection of laws within the territory of India. Through various case laws, we came to know that what is positive concept of equality and negative concept of equality and also arbitrariness. In E.P. Royappa, we studied that equality is antithesis to arbitrariness. A law should be just, fair and reasonable. There can be a classification which is reasonable classification and that classification has to be backed with intelligible differentia. And also the law should be just, fair and reasonable and there should be a procedure prescribed by law through which a fundamental right can be infringed. And also we read through various case laws how the golden triangle of 14, 19 and 21 attracts. If you like the video, please like, share and subscribe and do comment in the comment box.